It is the man, the myth, the legend. What's your name again?
All of the above, man, myth, and legend. John Watts is who we're talking about, right? John Watts, the man, the myth, the legend.
I
How
thought
are
we
you,
were talking
sir?
about you.
Yeah, well, I mean, that would be the men, the myths, and the legends. It would have to be
Ah,
both of us. So,
okay.
John, how are you this morning? This
Good,
afternoon?
good.
My goodness gracious, it's already half the day. I feel
Yeah,
like it's.
well, you got a little one. The world's kind of upside down, right?
I do, I do. Yeah,
When are you sleeping these days?
little baby girl. That's right, 3 months old. So, but welcome everybody to Legal Ease. This is where John and I get together and we try to educate you in between all of the entertainment. And so, for those of you guys watching live, put in your comments below. That's what we're here for, and we are going to talk about anything and everything credit, debt related. Man, what is on your mind? What is going on these days, John? Talk to us, buddy. What's happening?
Yeah, and I mentioned this to you. And for those of you who don't know, we do extensive preparation for this thing, and we usually text about 2 minutes before the top of the hour. And but I told Steve this time I've got some meetings after this, so I've got sort of a hard deadline of 1 hour, and so hopefully we'll have some questions. If we don't, then we'll have the world's shortest legal ease show here. But
We will. I mean, can you believe what a world where 1 hour is in fact like the shortest legal age show? Sometimes these things drag on for 2.5, and then I'm like, oh my gosh, my butt's sore after that for sitting down for so long. But looks like Elvis is giving us a little like sign, man, in Facebook. Post up your questions, your comments, guys. What you guys are seeing out there. Speaking of what we're seeing, John, what are you seeing out there, man? Now that we've got that, Regulation F is now in full force. Is that right? The debt collection regulation?
yeah, so it's very helpful. I think there's a couple aspects that we're seeing. One, it does open up the electronic communication, which is kind of nice. I know a lot of consumer advocates didn't like that. I like it because the consumer has the choice on, do I want to receive emails, texts, letters, phone calls? You can dictate to the collector what's convenient for you. And also, there was a sort of a weird deal, Steve, where the debt collector would send you this initial letter that says you have 30 days to object, basically, or dispute. And the question always came up, well, 30 days from when? From when they mailed it, when you received it. And now they give you a firm deadline. And basically, they, at least all the ones I've seen, put it about 45 days out from the letter. So I think that's helpful to consumers.
Look at that. That I could just tell. Firm deadline. That was a legal term, and I'm just sitting here imagining before Regulation F with the firm deadline. That's probably what you went and argued before the judge. You were like, Judge, this thing says 30 days. There's no firm deadline. We don't know what this thing is, Judge. Poor us, poor consumer. I'm just sitting here
That's 30
thinking,
days from receipt. And then they would say, well, you must have received it earlier. And so, but anyway, it's helpful because, I mean, out of everything about Regulation F, I think the ability to control what communications come to you. So you can send a letter and say the only convenient form of communication is email and text, or it's phone, or it's letter, whatever you want.
like
And
like
then,
like like Twitter and Facebook Instant Messenger. Like, can you
yeah,
go
you
ahead and
could
narrow
you could
it down?
say that.
TikTok. Send me a TikTok video
Yeah,
portfolio recovery.
you're the TikTok guy now. So I think it's good. And let me grab some of these comments here. So couponing at its finest. Appreciate you guys' knowledge. Well, you are very, very welcome. And then let's see. I'm not sure how you say that. Leakager 06, something like that. So we appreciate your comment. We did get this. So
Yeah,
um,
that's Hope
hopefully,
Perez. I think it may be on her end. Because
yeah, yeah, maybe if you other guys that are watching, if you can let us know, if are you able to hear us, see us okay? From our standpoint, it looks fine, but you know, you guys are on the.
I mean, I'm hearing you okay, John, and that's kind of unfortunate because sometimes I wish you would be fading in and out, but I hear you loud and clear, sir. When you say the things that I don't want to hear, you know, then I'm like, can you fade in and out for that? Sometimes you pop my bubble, man. But
I had a trial one time. I was asked to help in this trial, and this our client was this older guy. And so when I was questioning him, he could hear everything. And when the other side questioned him, he was like, What? I can't hear you. And he was just trying to be annoying. And I pulled him aside in a break. I'm like, What are you doing? He's like, Oh, I'm driving them crazy. I'm like, You see the jury? You're driving the jury crazy. So, yeah, but I understand. Sometimes you want to not hear my opinions.
So we got Regulation F. So it makes social media. I mean, we're kind of joking, but like now they can send you a Facebook DM, can't they?
Right. Not a public, but yeah, direct message on
Yeah,
any
they can like
social
post
media.
up tag on your page like, John, you're a deadbeat. You owe us $2,500. Boy, wouldn't you love to get that one, huh? My goodness gracious, would that be a slam dunk or what?
Yeah, that would be unfortunate.
Do you remember the Wolf of Wall Street, John? You ever seen the Wolf of Wall Street? Of course you have, right?
I haven't seen it. I know who it's talking about, but I haven't
You've
seen it.
not seen the Wolf of Wall Street. Well, they got the feds, and the feds are going in there after they've been investigating Jordan Belfort, for all of his nefarious stock deals, and he's sitting there across the table from the feds, and the feds want to get him to wear a wire to rat on his other people. And one of the feds says, this case is what we call a grenada. It is unlosable. So what I'm trying to say is if LVNV were to go and like post up a debt collection on your Facebook, that would be a grenada, would it not? Like you just go to the judge and you're like, Judge, this is a grenada. Just enter a summary judgment in favor of my client right now, Judge. Let's just stop the pain. Is that right?
Yeah, unfortunately, when we get those cases, it's some guy living in his mom's basement with a prepaid cell phone that's the collector. So you don't typically get those with LVNV or Midland or
Living in the
the
basement. You talking about a Biden? Was Biden your client? Okay, I'm
he's
sorry
not in
about
the
that.
basement anymore, man.
We try to not get political here, but I mean, my goodness gracious. All right, let's get
Let's
into this.
see.
We all have a sense of humor here. You guys don't tune in to not be offended every now and then. All right.
Yes. So to answer your question, yes, please ask questions. So any kind of consumer related question about credit reports, debt collectors, things of that nature, and we will be happy to
Yes, sir.
answer
Post
those
up,
for you.
Punlo. We are here for you. So, all right. Well, while we're waiting for the questions to come in, John, let's talk about something exciting. Let's talk about some stories, man. Story time with Uncle John. Give us some court cases or something that some stories that we can take away and just be like, oh my gosh, that's amazing.
Well, and I see we have a question come in. I tell you what, I'll save the story for when we get a break in the questions
All right.
here.
There you go.
So here's Gary. What does a refusal to pay letter need to say? Is it sufficient enough to say I refuse to pay this debt? Or does it also need to say, do not contact me in order for it to be an FDCPA case if they respond? So it's a very, very good question. And Mr. Stephen, how would you respond to that?
Well, I'd say that there's actually kind of two parts of the FDCPA potentially that you're trying to cover with one letter, which is okay. I mean, you have you have the right to tell them to cease and desist. Okay, I mean, so how do you tell them to cease and desist? I mean, so if you say, hey, I refuse to pay, I'm not the lawyer, but I've been on this show enough times. I know from my good friend John Watts, if you tell them you refuse to pay, they are supposed to interpret that as like a cease and desist, basically. Like, why are we gonna harass this poor guy when he literally has told us he's not going to pay? So I think if you put one or the other, it should be sufficient. If you put them both, then it's kind of like double whammy. John? Correct?
Yeah. So that's right. So let's look at the law. This is 1692C of the FDCPA. And then if you come down to subsection C, if a consumer notifies a debt collector in writing, now Regulation F has changed this slightly, but just talking about a refuse to pay letter, this is still good, that the consumer refuses to pay, or so you don't have to do both. You can do one or the other. You can say, I refuse to pay, or you can say, hey, I want you to cease further communication. Then the debt collector shall not communicate further except for some few minor things. So the point is you can say a Uh, I mean, it literally can be, hey, I refuse to pay on any debt that you claim I owe, period. And then give your identifying information. You want your address, your name. I like to give date of birth, last four social, just so there's no excuse for them to say, well, Stephen, we didn't know who you were. But you can say cease communication. You can say refuse to pay. It's all the same thing.
Now,
And
what if you say, hey, man, I refuse to pay until you provide me with A, B, C, X, Y, Z? How would the courts interpret that? Is that like a gotcha, or the courts could be like, you're too sneaky? No, we don't like that.
yeah, I don't think they would like it because it's not really contemplated by the statute, and you're saying almost contradictory things. Like, I don't want you to communicate until after you communicate with me and give me what I want. And then there's
John,
going to
it makes perfect sense to me. I don't want you to communicate until after you communicate. I mean, you guys post up here. Let's do a little survey. Does that make perfect, clear sense to anybody else? It does to me. My goodness.
So Karen says, good evening to both. Hey, good evening to you.
Karen.
Or
How
as
are you?
Stephen would say, good morning.
Good morning. That's right. That's right. When the meetings just stack up, and next thing you know, half the day is gone.
Let's see. I'm a pro se plaintiff in an FDCPA suit. And just so everybody knows, pro se means without a lawyer. So Chrome Noob here is doing this on his own. I believe opposing counsel is not being truthful on their corporate disclosure. And so evidently this lawsuit is in federal court, and almost every federal court, at least the corporate defendants, and sometimes even as an individual, you have to file what's called the corporate disclosure, which Stephen's sitting there going, well, how do you do that if you're an individual? You just say, I'm an individual, not a corporation. It's sort of silly. But for the companies you sue, they have to disclose, who owns them, who has a controlling interest, things like that. He says the collector is Altran, a subsidiary of Trans World. So I would say, if you think they're not being truthful, talk to the lawyer and say, hey, here's why I think you're not being truthful. Will you, verify this information? And if you need to change it, will you change it with your court filing? And if they won't work with you, you could always file a motion with the court to take a look at that. Just if you file a motion, I would be really, really certain that you're solid on what you're saying legally and factually. And just so that if you pick a battle, you want to win the battles. You don't want to start off losing the battles. So that's what I would say about that. Here is David Thompson. Good afternoon, gentlemen. Does original charged off debt that's also bought by a debt buyer stay on your credit 7 or 10 years? When does a debt buyer account delete? So why don't you take the first answer for really both of those questions, because it's the same answer.
Yeah, so a couple parts of that. So for the obsolescence period, as it's called in the FCRA, that's 1681C. I wish maybe John could pull that up here. Basically, you have 7 years from really 7.5 years. They give you 180 days from the delinquency, the date of first delinquency, 180 days, and then that 7-year purge clock starts. So if the transfer of the trade line from original creditor to debt buyer, if everything's accurate, that date does not change. So your original trade line is going to have up to 7.5 years to report before it's purged out. And any subsequent chain of reporting ownership would be that same date over there. Now, you say, when do they delete it? Well, there's a distinction you should know between debt buyers and debt collectors for credit reporting purposes. So if it is a third-party collector, if they're done collecting on it, or if they can't collect on it and they have to give it back to the creditor, or if they close the account, the creditor does what's called recalling the account, that trade line gets deleted by nature of Metro 2, which is their reporting standard. So debt collector accounts, you cannot have, if you're just going to go from debt collector A and then they're going to pull it back and give it to debt collector B. Like, let's say you got, the medical bill, whatever, probably a bad example now, John, now that medical bills, low dollar medical bills aren't reporting, but, well, let's say you got the the apartment charge off, right? The apartment complex, and then they've got a debt collector A report collecting, and you send debt collector A a cease and desist, and then they're not a buyer, but they're the debt collector. They give it back to the apartment complex, and the apartment complex gives it to debt collector B to harass you and oppress you and abuse you. And you tell debt
And lie
collector,
to you.
what's that?
And lie to you.
And lie to you. That's right. That may be the most favorable, nicest of all of those things right there, right? Don't oppress and abuse me, but at least you can lie to me. I can take that. Anyway, so if you have multiple debt collectors, only one of those can stay on your report at any one time. Debt buyers, though, it's because they own it. If debt buyer A then sells it to debt buyer B, you can have original creditor, debt buyer A, and debt buyer B on your credit. But if you look at the time period, they should never overlap in time period of the account status, right? So like if this thing, original creditor sold June of last year, and then July of last year, the new one starts reporting, and then they report until February of this year, and then March of this year, the third one starts reporting. So that is, I forgot the question here, John. My goodness gracious, I was talking on a tangent here. That's why you guys love watching me. Yes, so John, I was waiting for you to pull up the statute. 7.5 years, and then they're not obligated to delete it until that 7.5 years. In reality, all three of the bureaus don't wait 7.5 years. Usually they purge out somewhere right around 7 or just under 7 years. Okay, I'm done, John. Go ahead and take it away, sir.
Yeah, I think you answered that. So let's see. Chrome.
For those of you guys watching for entertainment purposes and not for education, that's John's nice way, basically telling me that I talked a little too much there in that last segment. Go ahead, John. I'm sorry, buddy.
That's all right. What do you do? Compel the other side to disclose all parent corporations. This is if you're in federal court. And Chrome, that's what we were mentioned just a moment ago about. I would just start with the lawyer defending the debt collector you sued. Show them the evidence that you think their disclosure is not accurate and ask them about it. And ultimately, you can file a motion with the court. Let's see. We've got Drude. Hello, everyone. Hello to you. And here we go. I have a good one. I have a creditor listing a charge off $960 over the amount owed from the deficiency. So, Steve, this may be like a car deficiency, repo deficiency. So I'm assuming they did 1099-C claiming $960 over what they should have. Is this tax fraud? So you are involved in taxes to some extent, aren't you, Steve? Or bookkeeping?
Well, I definitely would say it's not tax fraud unless somebody went into it and said, we're gonna intentionally evade something here, with taxes. So I would say it's definitely not tax fraud. You may have things that are misreported. You may have errors, but that fraud is definitely kind of, I would say, definitely not going to be that.
Yeah, and I think one thing you could do is, so I'm assuming that this was like a car repo, and they said you owe, $5,000, and now on your credit report it says $5,960. Well, there may be some other explanation for that $960. You could always ask the company that's reporting it, how do you get this number? If you have documentation showing the amount owed is only, for example, $5,000, and it's reporting $5,960, you may want to dispute it with the credit bureaus, showing that documentation, saying, guys, how can this be $5,960? I've got the proof it's $5,000. So I would not, seeing $960 over the amount would not make me think that the 1099-C has been issued. I mean, if a 1099-C is issued, you're supposed to get that. You don't always, but you are supposed to. It's supposed to be mailed to you. So that's what I would look at.
The question is, did communicate with them and ask for a statement of account? Really, that's the simple way to say, hey, give me a rundown. That would be your starting point. And then if they can't give that to you, well, boy, I mean, then you're just going fishing now. It's like, what else can you reel in as far as the non-compliance and the violations? But that would be the starting point. Put that in a nice little letter and say, hey, it looks like, I wouldn't put the assumptions. I would definitely leave the assumptions out, but I would stick to the facts. Facts are you're charging 960 over the amount owed for the alleged deficiency based on. So what is that based on? Based on your credit report or what? I'm confused. I'm always confused because I'm just a poor consumer. You're the big company. So please send me a statement of account. Thank you. And I think that would be your starting point for that issue. What are your thoughts there, John?
Yeah, and then if they send you something back that says you only owe $5,000, well, now you've got that to take to the credit bureau. So I think that would be a good starting point. Let's see. Kenneth says, is there a specific way to know if you have a federal case? I've sent a dispute letter challenging my personal information, inaccurate data, incomplete data. Update came back worse. So let's talk about that last part. Update came back worse. So I don't know exactly what you mean by this, Kenneth, but let me give you sort of an idea. You may have something that is missing 4 months of data and you dispute it. And so they correct that, they make it complete, they make it accurate, and maybe those 4 months are charge offs. So, in a sense, that can make it worse.
Well, now in this case, he's talking personal information, though. He's talking his identifiers. So the question there, Kenneth, is like, did they put in an address? I see this sometimes. We'll send in a dispute for our clients. We've got a little PO box on the return envelope, and our PO box address will be inserted into the consumer's credit report. We see that sometimes. So, like, maybe you could post up again, Kenneth, and elaborate how did it come back worse with respect to your personal information. But John, so to his point, though, I mean, if he puts them on notice and says this is inaccurate, personal identifiers, you can litigate against that if if you put them on notice and it's not fixed, correct?
Yeah, I don't think I've ever filed one just on personal identifiers, and I took the question to mean personal information plus then there's inaccurate data, incomplete data. So I'll say this as sort of my rule in my law firm. When we're looking at disputing something, we have two questions we ask. Number one, is there data that's inaccurate or incomplete? Now, if the answer to that is no, in other words, everything is accurate, everything's complete, well, then we're not disputing. But if there is something that's inaccurate or incomplete, second question is, are we comfortable disputing this? And what I mean by that is they can always just delete the account. And sometimes people say, well, no, I only want this 30-day remove. I don't want to lose the whole account. Well, they have that right to delete the whole account. And sort of the other side of that is if they're missing data, they could update it. And it could be negative information that they update with. As long as it's accurate, that's okay. So you do have to use some judgment in what do you dispute? Are you comfortable if they deleted it, if they made it complete? My view is we're never going to complain if they make our data accurate and complete. I'll say this. It's very, very rare for them to make the data actually accurate and complete. Okay. But I suppose it's theoretically possible that happens.
See, now John can say those kind of things because he's an attorney. If the average normal person were to say that, boy, if you get subpoenaed by the credit bureau, they're going to be like, do you mean to tell us, Mr. Watts, that the law requires maximum possible accuracy, but you've never seen an accurate credit report? And then John would have to say, yeah, that's exactly what I mean to tell you. You guys suck.
Well, I might not say the last part, but I would say, yes, that's what I mean.
I'll say that for you. Okay. We'll keep you as the good cop. I'll be the bad cop over here.
Okay. So here's Drew. After settling for less than the amount owed and paying that settlement off, how soon is the creditor expected to update the credit report reflecting zero balance settle? So it's a very good question. I'll take kind of two parts to this. One is, when did the money actually get to the creditor? And we have to then distinguish, is this like a personal check that they're going to hold for 2 weeks, or, what's happening there? But when it's paid, then at that point, they should show you as a zero balance. Now, what we are seeing quite often, and I've got some cases, I think one I'm filing tonight, probably one tomorrow, against the credit bureaus and the furnishers, is where, let's say we pay in July and everybody agrees we paid in July. Now, we might argue with the bureaus about should July show a zero balance or not, but then August will show a pause or a balance more than zero and show charge off. Well, there's no way that can possibly be accurate. If I paid it off in July, I can't be late in August. So there can't be a charge off or 180 days or 60 days or 30 days late in August because everybody agrees I paid it off in July. Now, again, they may get the check. They may say, well, we got to hold it, let it sit in our bank account. But I would say whatever the date is, they received the check or they received the wire transfer or the ACH draft or whatever it is, I would say that's when they were paid and they need to update. Now, they may not update literally that day. You may be in another cycle before they update, but they would have to go back and make that information accurate. So if you paid it in July, even if they updated it in August, they got to say it was paid in July.
Now, I do have kind of a caveat to that. If a furnisher has previously ceased reporting, I mean, they can just stop reporting at any point in time, then technically they don't have an obligation to continue to report when you paid it off unless you dispute it. Now, if you dispute it, then they are supposed to update it, record the current status. So, I mean, 95% of the time, yes, they're continuing to report on a monthly basis. So then, hopefully next month they update it. But just keep in mind, if they were like stopped reporting it 2 years ago, then you can't like force them to update it. But then through a dispute, that mechanism should force them to update it. Is that fair to say there, John?
Yeah, and you would want to include the proof that you paid this. Maybe here's a settlement letter. Here's my bank account showing the money go out, the exact amount in the settlement letter, and say, get them to update if they're not going to make it. I mean, this is our standard approach. If it's not going to be 100% accurate or complete, then delete it. And so it's not complete if it's not showing your last payment. If it's showing a positive balance, when I say positive, I mean, more than zero. And so, like Steve said, even if they go, we're just going to park the account on your credit report. It's like, that's cute, guys, but I can dispute. And it's either going to come off or it's going to be 100% accurate and complete, or I'm going to sue you. I mean, those are the three options. So delete it, fix it.
I don't believe, I've read the FCRA quite a few times. I don't believe I've ever found the term parking that account as something under the FCRA. Do you mean to tell me that there's furnishers out there who completely abuse the credit reporting system? Is that what you're trying to tell our listening audience here?
I know you're a kind soul, Steve, and you could never imagine that. But yes, there are companies that do that.
No way, dude. No way. That is
like if you need to drop off for a few minutes to sort of compose yourself, that's
I'm getting pale. I'm getting pale. Somebody over there Uber Eats me something with caffeine. My goodness, cappuccino.
Let's see. I'm having difficulty with removal of repossessions, even with using Prodigy, which I believe Prodigy is a software, sort of credit repair software. It is showing as original creditor and for only the difference in what they sold versus the amount previously owed. So that is what the balance should be, whatever the difference is. These are from 2018 or 2019 from Capital One and Harley Davidson. Any suggestions? So
yeah, I've got a suggestion. First of all,
we need to flash up, incoming commercial message.
First of all, we need to subsidize your Prodigy software with my software, which you can go to palmierisystemdemo.com, and I'm going to give you amazing factual Metro 2 letters. That's your first problem right there, Facebook user. Okay, go ahead, John. I'm sorry. I just couldn't let that opportunity go to waste.
No, I'd say whether you're doing this sort of manually, using software, the idea is you're challenging information that's inaccurate or incomplete. Sometimes people get hung up on, well, this is not a challenge, this is a dispute, or this is not a dispute, it's a challenge. I can't keep that straight. The courts don't care anything about that. What the courts care about is, did you notify the credit bureaus and let them know specifically what is wrong with this account? And did they fix it or delete it? If they didn't fix it, didn't delete it, then you sue them. And so let's take an example. If I have a car, $10,000 on it. They sell it at auction for $4,000. Well, then the balance should be 6, not 10. Now, historically, it should show that it was 10,000, but once that repo sale happened or auction happened, the balance should go down, and that should be reflected in the current balance. So, if you want to give us some more information about maybe what you're challenging, what's wrong, I don't know sort of what the methodology is with the Prodigy software, if that's finding the errors or if that's taking a different approach, but you're welcome to put something on in the comments here. Let's see. Are all collection agencies committing identity theft? They will never show you that they legally own the debt. So the short answer is no, they're not committing identity theft. Identity theft is when when somebody opens an account in your name. Here, the collection agency is not saying that they're you. They're saying, hey, we're stepping into the shoes of Bank of America or Capital One or Santander, whoever it may be. Either that we own the debt now because we bought it, or we've been assigned it for collection purposes. So we certainly, when a debt collector or debt buyer sues us, we want them to prove that they own the debt because we're in a court of law. Then they have to do that. But just sort of interacting with them, they don't necessarily have to prove that they own the debt. It also depends on how you word things and what exactly you ask for, and what's your basis for saying, hey, debt collector, you don't have the right to collect this. Let's see. We've got Sharice. Good evening. I disputed a collection account. They said file was sent my account to a lawyer, so I never got notice. I just checked court website. Said the case was disposed of in 2021. Shouldn't they remove it now? So, Sharice, a great question. My question for you is, when you say it was disposed, was there a verdict against you? Was there a verdict in your favor? Was it dismissed with prejudice, without prejudice? All of those things make a difference on whether they can continue to report. So if I get sued and I lose, they can certainly continue to report at least what the judge said I owe. If I win, they can't credit report that I owe it because the judge says I don't owe it. If it's dismissed with prejudice, that's really the same thing as winning, and they shouldn't be on my credit report. So I would just want to know a little bit more details about what exactly the court website says. Stephen, here's one. Can debt buyers report late payments? This is a really good one, such as portfolio recovery, LVNV, et cetera, which I notice they report negative history on Equifax and TransUnion. And so, sometimes when you look, I'll do it this way, maybe it'll show up correctly. You'll see a C throughout the payment history. Can they do that? Can they actually, Stephen, I saw one of these, they reported like 120 days late. It's the weirdest thing. Like a debt buyer.
And this is Elvis's question. I think that's what Elvis is asking, is like not to see, because they can report it as collection, each month, but it's not supposed to have like 120 or anything like that, because you're defaulted and it's transferred to a collection, and Metro 2 has its own specific, there's a whole chapter at the end of Metro 2 for collection reporting. And when not to get into the weeds here, John, but that's what we do. When it goes into a collection, so there's what's called the portfolio type. That is one of the primary data fields for accounts. And there's 5 portfolio types: mortgage, installment, revolving, line of credit, and open. And open is like an account that's kind of like due on demand. So when, let's say, a credit card, which was a revolving account, is charged off, if it goes to a collection agency kind of under the reporting guidelines, they're supposed to report that the debt collector as an open portfolio, which basically means it's due on demand. So the whole nature of the account changes, and it should just stay reporting collection. So if you're seeing, 30 days, 60 days, 120 days, make a beeline to John, because that's going to be something juicy for him, in my opinion.
Yeah, and I would just be very curious, how often are you seeing that? I think I've seen it once, and I mean, like the last 1,000 credit reports, and it kind of jumped out at me. It was so unusual. I just don't really see it. Let's see. Here's a good question from Melissa. Hello. Midland fell off of my credit report in May this year. Can they add it as a delinquency again? So if it fell off because of the age, what fancy people like Steven call the obsolescence period, then it cannot come back on because it would be too old. Now, there could be some other reason it came off. Maybe there was litigation, they took it off, and then they put it back on. But if it, I'll just say this: if Midland comes off your credit report and then it comes back on, you need to have somebody look at that. Get with the lawyer in your state to take a look at that, because that, I'm not saying it's always wrong, but it's a big, like giant red flag, flashing lights, like, hey, there's something going on here. So, but hey, congratulations, it came off. That's wonderful.
Yeah, because when they reinsert it, they're supposed to like certify that it's accurate and stuff like that. And so, I mean, the question is, are they playing games with your credit report? What's really going on there? Why did it come off? If it came off as a result of a dispute, then they really have problems if they reinsert it, because then they previously deleted it, de facto admitting they could not figure out how to fix it in 30 days. And that's the whole point of the law having a 30-day dispute period. Is like, look, if these guys can't figure it out in 30 days, it's supposed to be deleted. It's not like, oh, just delete it for like, 6 months until you get around to figuring it out. No. So then the question is, did it fall off as a result of a dispute or just kind of organically for some reason?
Yeah, and if it came off as the result of a dispute and then it's put back on, the credit bureaus may have some liability for that. So you may be looking at Midland breaking the law and the credit bureau. So I don't think it'll come back on for you, but if it does, let us know. Be interested in knowing the details of that. So here we say, question is too long, have to send it in increments. So $4,000 loan, first payment due is $285, next payment jumped to over $800. It's kind of odd if it's a fixed payment installment loan, now over $1,000. Is this legal? Customary fee amount was never disclosed. Can I sue? Should I request to settle? Already paid in the last 7 to 8 months more than the amount I borrowed. So a couple thoughts would just be, and it may be hard to put this in the chat, but I would just look at this and maybe ask the company, like, why is the change? I mean, if the first payment is $285, did we make that payment? Did we not make it? Did that get added into the next payment along with some late fees? That would be hard to believe it would add up to over $800. But
well, and let's jump in a little bit. So I'm assuming this is a consumer loan. So if it's a $4,000 loan and you're paying $800 a month, so this, I would assume, if it's a consumer loan, because if it's a business loan, they could charge you some hellacious ass interest rate, and But if it's a consumer loan, then is it a payday loan, which kind of have a nice little way of circumventing interest rate caps. So then the question will be, usually when you have a payday loan, there's kind of like, I'll call it that origination fee. They charge you something right up front, and then there's like the actual loan payments. So was it a payday loan? Was it 285, which you had to pay them like right there when you walked out the door? And so kind of some questions. If you want to clarify a little bit below, we may be able to dig into it a little bit in a little more detail.
Yeah, and sort of following along with Stephen's point about payday loan, it might be an online loan that is made by somebody who says, hey, I'm a member of a tribe, and so I'm exempt from all regulations. And the courts have been pretty skeptical of that. So you definitely want to look at your paperwork, see what it says, and if it looks sort of fishy to you, then I would get with the lawyer in your state about it.
John, I'm a member of the Good Vibe tribe. Does that mean I can go ahead and just violate all usury laws, or does that not qualify me?
You would have as much right as anybody else.
All right. Well, there you go.
So here's David.
Way to burst my bubble, man.
So this is not shocking. Experian is being difficult about addresses. So Stephen, you are all knowledgeable about credit reports. What to do when Experian won't remove old addresses because they say, well, that's attached to, and they never tell you which accounts, but
yeah,
those are attached to some accounts that you have.
Yeah, so that's part of it. Is the address attached to an account. If you pull your annual credit report, those addresses have like little codes which correlate or coincide to the trade lines. So you can see, is that address, does it correlate to a trade line? So typically Experian won't delete them, or it gives you grief if it's attached to a trade line. So that's kind of thing number one. But hey, that goes into the not my problem bucket in reality, right? So if these addresses are really inaccurate, and they're giving you grief, I would put some sort of an affidavit together, and I would just say, hey, these addresses are inaccurate for the following reason. I haven't lived here in 20 years, so therefore it's irrelevant, or it's inaccurate because it's really like wrong. Put that in an affidavit, send it to them, and if they still tell you to go pound sand, then I would talk to John. I mean, hopefully you've got some other trade line issues as well. Like he said earlier, he's not really going to sue over just information for your personal identifiers, but I mean, if he can bundle that up, look at that term right there, John, bundle. We're going to go ahead and bundle your claims up. We'll sprinkle a little bit of this, a little bit of that. Oh, some personal identifiers along with, your Santander repossession. Just throw it all in there, mix it up, and then present that to the judge. But in all seriousness, I would put an affidavit together, send it to them, and if that doesn't do the trick, I would go talk to John.
Yeah, and the other thing is look really, really closely at those addresses. I mean, accuracy means it's 100% accurate. So, if you lived at 123 Main Street and it says 132 Main Street, well, that's not accurate. My last name is Watts, Watts. So if they have me Wats, that's not accurate. And I'll say this: I have sued and I will sue over when like Experian is terrible about having Social Security variations and not fixing those. And so that's personal information, but I'm not sure if I've ever sued over just an address. But I'll say this: if you have any negative accounts, Experian will have errors in there, almost certainly. So just check that out.
John, I'm detecting a pattern and practice of you basically bad-mouthing Experian's ability to create maximum possible accuracy reports. Am I misinterpreting your vibe, or is that a fair assessment of how you feel about them?
They don't send me Christmas cards, so
but they do help you pay for your Christmas gifts.
Their checks have never bounced, so I will compliment them on that.
Yeah, it is
something. All right, so Charisse, this is she had the case back in 21, and it was disposed. So, Charisse, what you'd have to do, I don't know what state you're in or how much detail you can get online. You may have to call the courthouse and say, how was this case disposed? Normally, there are, we might say, 4 options. One is a judgment against you. One is a judgment in your favor. One's a dismissal without prejudice. Some courts call this a non-suit. Just think of that as almost like the suit never existed. You didn't really win. You didn't lose. And then there's a dismissal with prejudice, which is really the same thing as winning your case. And so I would just find out which one it is, because if it's a dismissal with prejudice, that could be very helpful. Let's see, you're on my YouTube channel. I think probably the most recent video upload I did was maybe a week ago. Is from a webinar. And if I remember right, the whole video, it's like an hour and a half, is about, all right, you are successful when a debt collector sues you. You get a verdict in your favor. You get a dismissal with prejudice. What do you do with that? What does that mean for your credit report? So if you do find out that it was with prejudice, you might want to take a look at that video and then get with the lawyer in your state.
An hour and a half video? I didn't know you could do videos that short, man. I thought you had to go at least 2 hours plus, man.
I think the internet cut out. You'll appreciate this, Stephen. I had this case against a bunch of Wall Street banks. It was a securities fraud case. And we had the case down in Miami, Florida, and they wanted to bundle it with these other cases. See that word that you taught me, bundle with these other cases. And so it's called now I'm drawing a blank on the process for it. But anyway, so we had this court argument about whether our case was going to be sucked into all these other cases. And so I flew to Rhode Island and going to argue it there. That's where they were holding it. And I went up to them and they said, "All right, you have 3 minutes to argue." And I said, "I'm from the South. I can't say my name in 3 minutes. You got to give me more time." And this lady looked at me and she's like, "All right, I'll give you 5 minutes," And so yeah, it takes me a while to do these, webinars. So, all right, let's see what Kenneth has got here. It's almost like they deleted the whole payment history. So let me go back real quick here.
Yeah, they do that sometimes. They delete whole payment histories. They make the trade line even less complete and accurate. Isn't that something, Kenneth?
Yeah. So, okay, we're challenging personal information, inaccurate data, incomplete data. And so it looks like they deleted the whole payment history. Also have 2 last names. So they have also known as wrong addresses, employers. So this is my thought. I'd be curious what Stephen thinks. I'm not sure we've ever talked about this, but I think when they come in and just wipe out the payment history, like maybe the trended data, and they just wipe all that out, well, unless they have literally cleared that from their servers and it exists nowhere, then they're supposed to give you the information in what's called your file. You're entitled to a file disclosure, consumer disclosure. And so if they've wiped that out from your credit report, but they still have the data, I think they have to report that to you. They have to give you that information. Or, as Stephen said, it's even more incomplete than it was before. And
forget about if they have the information or not. If they're going to report anything on the trade line, it needs to be maximum possible accuracy. So if they can't figure out how to find the payment history, whether they're suppressing it or it's just gone, their server disappeared, they can't report that trade line without the payment history. My goodness gracious. It's like buying a Maserati without 4 tires. I mean, what are you going to do with your car and cinder blocks? Huh, John?
That's right. How much do you think tires cost for a Maserati?
Oh, gosh. I mean, it depends. Oh, my goodness gracious. We're getting off tangent here. Let's get focused.
That's right. We got the clock's ticking here. All right. I have a debt buyer with an account from previous apartment. My ledger shows 0 upon move out. Sent a 1692G. That would be like a dispute or validation letter. They gave me a sheet of charges dated 10 months later. Can I sue? So it's a very good question. Here's hopefully a short answer. It gets a little complicated in this area because the collection agency is not the apartment complex. They're going to say, well, we're just relying on the apartment complex. You're saying the collection agency is collecting something that you really don't owe because you were told you owed 0 when you moved out. Now, you need to know, like, what does the lease say? What were you told? In other words, it might be like, oh, yeah, Stephen, you're paid up. But if you trash the place, there's going to be cleaning and repair fees. Or was this after they did an inspection, they showed you a 0 balance? So I wish I could give you just a definitive answer, but it's certainly something I would look at and, point out to that collector, hey, this ledger's from 10 months later. Here's the 0 balance when I moved out. You cannot trust this apartment complex because obviously they're like making stuff up 10 months later. And I want you to, get rid of this. Now you say it's a debt buyer. Most of the time with apartments, I'm not seeing people that actually claim to have bought the debt. But if that's true, now that debt buyer kind of, pardon the pun, but if they are truly a debt buyer and they own the debt, well, then they own all the problems with the debt. If they're a collection agency, they almost have a little bit of layer of insulation until you tell them there's a problem. And I mean, this gets like, there'll be 40-page briefs in federal court arguing over this. So I can't give you all the facets of it, but I would say make the debt collector aware of what the problem is and see if they back down. Let's see, here's a question. Does Cardoza, talking about, we presume, the one and only Michael Cardoza in California, does he sue credit bureaus? Yes, he does.
Is he still alive? I haven't seen that dude in ages. My goodness gracious.
Yeah, we did
a guy to do a show with.
He and I did I think a Zoom yesterday. So He's alive. He's suing the bad guys, so it's all
right.
good.
We love Cardoza.
All right. If attorney's fees are included in the suit, do the lawyers also take attorney's fees from the client if the case was in favor of the client? So I think you're talking about, like, let's say you sue a debt collector, and under the FDCPA, you're entitled to attorney's fees, and that's claimed in the lawsuit. How does the attorney get paid? That's really going to depend on the contract. Yeah, I'll give you sort of two extremes, not like either one's bad, but sort of two sides of this. One is some lawyers say, I don't want any percentage of the recovery. I just want my hourly rate. Now, it could be there's a $10,000 settlement and their hourly rate is $9,900, and they say, here's $100. Other lawyers take the position, hey, we'll take a percentage. We'll take, 50% of whatever you get. And then others have sort of a hybrid approach. So there's different ways. You just need to talk to your lawyer before you hire them about, okay, how will this work? And I'll say, I mean, there are lawyers that end up getting more than their client. I'm not sure how common that is. I'll say at my firm, that's very, very unusual. But I know other lawyers have kind of a different business model, and they'll say, hey, the first $8,000 or $10,000, we get like $9,000, and you get $1,000. And so you need to know that going in, before you hire the lawyer.
John, I think I saw a Yelp review for your firm. I don't know, maybe this was a spam bot, but it said that this guy went to your firm and it was this exact issue. And he asked, what's the fee going to be? And you replied by saying, depends on how much we're going to get and also how much you got. Is that how your firm operates, or was that some fake news Yelp review that I saw out there, man?
I have no idea if I have a Yelp review. All Yelp does is, they are like, hey, you should pay us money and we'll protect you from bad reviews. I've seen some movies on that. I think, like a protection racket. Let's see. Here's a very, very serious. This guy is a thoughtful guy, and when he speaks, you need to listen to him. And I mean, yeah, he's convicted me. And in 8 minutes, I'm going to not hang out with Stephen Palmieri. So thank you for your encouragement, Robert.
Robert Sigmund, you are basically going to be deplatformed from watching this show, okay? Officially.
That's right. Stephen Palmieri has like his own platform, and he can cancel people. All right, let's see. If a debt buyer reports inconsistent information, date last active, different across 3 bureaus, disputed several times, sue the bureau. Well, so you want to make sure you're looking at your actual reports from like annualcreditreport.com rather than a credit monitoring. But if there is different data, the same fields, different data, and you've pointed that out specifically and it's not fixed, it could be a problem with the debt buyer. It could be a problem with one of the bureaus or 2 of the bureaus or 3 of the bureaus. So it's not the easiest question to answer, other than to say you want to make sure you're letting people know this is a problem, and then really carefully studying the results that come back, pull new credit reports from annualcreditreport.com and see what it's showing. But if there's inconsistent data, somebody is at fault. It might be one bureau, it might be all of them. And, my approach in that tends to be to sue them all and let them point the finger at each other.
Like the Marine Corps motto, kill them all and let God sort it out. That's kind of how you feel about the litigation arena. Is that what I'm hearing, John?
Well, I think it was, wasn't it Michael Creasy, A Man on Fire, where the lady said, do you believe in forgiveness? And he said, that's between them and God. My job is to arrange the meeting, or something like that. It's a great revenge movie, Denzel Washington.
There you go.
All right, let's see. Smart credit identity IQ. Okay, I think he's talking about the date of last activity. You don't really see that on the actual reports. Let's see. I will need a new demo of your software. This said TransUnion remove both.
That is Hope. I've got you scribbled down here on my piece of paper. I'm going to make a beeline to you after this show.
Very good. There's common data glitch on those reports. They say 120 days late when they're in collections. That's interesting. I've only seen that one time. I'd like to see it more.
That's Scott Schaff.
Good.
Scotty.
It's only reinsertion if it's by dispute. They voluntarily took it off. They can put it back on. Yeah. All right. So we're going to do a rapid fire thing here because I've got a phone call. Let's
John,
see.
can you? I mean, you just told me you went in front of a judge and said that you couldn't speak in 3 minutes because you're from the South, and all of a sudden now you've got rapid fire mode in you. I don't believe it. Go ahead
Yeah.
and prove me wrong. Let's
We're
do
going
it.
to try. All right.
All
Age
right.
was from April 2016. So I guess it was old. Debt collector and I are in court, which is another headache. That might be why they've deleted it, because if you're in court, they may say, well, I don't know if you sued them or they've sued you, but I would definitely keep an eye on, your credit reports. Let's see. This is that loan that had the weird payment amounts. It's a consumer loan, flex loan, line of credit, no origination fee, and then online loan. Yeah, I would just look at the terms really carefully. And this is one of those things where I know I'm guilty of this, sort of saying, well, I can keep it all straight in my mind. You really got to put pen to paper or, fingers to keyboard and like draw this stuff out and write it out and see, okay, exactly what's supposed to happen here. Why don't you take this one, Stephen? Can a collection agency add a trade line collection account with a new account number and account name without you signing a contract with the collection agency, never doing business with them?
Well, it still has to be the same trade line. They can assign a number, an account number to it, but I mean, they can't open up a new credit account without your authorization. No.
So, well, I'll answer it this way because I was reading the next question. A collection agency doesn't need a contract with you. Their contract is with the original creditor. And so they don't have to ask your permission to collect. Your contract has the ability to be assigned or sold to somebody else. Let's see here. I can barely see you, Palmieri. A person who has a late payment reporting from 2 years ago, it's not affecting his credit score. However, the late payment's reported because I think it's a bank. Bank switched systems, as automatic payment did not get taken out. Bank admitted 2 years ago, switched systems, won't remove late payment. What would be his claim if we were to sue? So there's a concept when we're talking about accuracy. You have sort of technical accuracy, but there's a recognition sometimes technical accuracy could be misleading. And so most courts say if information is technically accurate but yet misleading, then that's something you could sue on. This is also would be a great reason why the account should show that it's disputed. And so if you sued, it would basically be on this is inaccurate because he had the money. There's a bank made a mistake. They didn't pull it out. It would almost be not quite the same, but almost be like if I hand a check to the bank and then they lose the check and they're like, well, you didn't pay, so we're reporting you late. Well, not really. I mean, I gave you the money. Now here it's not quite as clean because you never gave them the money. They just refused to take it out because they changed their system. But I would look, is the account marked as disputed? And excuse me, have you taken that proof that the bank admitted they made an error, and have you submitted that to the credit bureaus?
But John, this is Jennifer Sanford. Wouldn't there be some recourse either under the EFT Act, the Electronic Funds Transfer Act, or potentially just breach of contract? Because if you've got an agreement with your creditor and they're supposed to suck that payment out every month, and they don't do that, that's a violation of I mean, so to paint the whole picture to the judge for the credit reporting, you throw those other causes of action in there, and it's like, judge, well, this is why it's inaccurate, because this credit report doesn't paint the picture that we had a contract with the creditor and they breached their contract, which then is showing up here, but this doesn't paint a full picture.
Yeah, and especially if the company that messed up, the bank or whoever it was, if you have an arbitration agreement with them, you could even look at arbitrating the case. And coincidentally, I'm sure it's unaccredited, but there's a Palmieri University.
John, allow me. We have a brand new, amazing product, arbitrationtrainingcourse.com. It is a training course presented by Shiva Bhaskar Esquire, who's an attorney. It's co-hosted with yours truly on Palmieri University. But if you go to arbitrationtrainingcourse.com for the temporarily discounted price of one-time $597, this attorney, Shiva, who's done hundreds of arbitrations against all these nefarious companies, he will give you everything you need to be successful. Thank you, John, for that little pitch time there, buddy. Appreciate you.
Yeah. Shiva's a good guy. So let's see here. We're going to go roll real quick. Made a payment when I didn't understand how debt collectors work. Attorneys for Midland Funding have no further information on how the payment was made. Can I use that as a defense? Well, my question would be, if you made the payment, you can't come into court and say you did not make the payment. So whether they can prove it or not, they would prove it by asking you, did you make a payment then? And you've got to answer truthfully. Let's see. Can you come to Vegas, represent me? I can't find a good FDCPA lawyer out here. Actually, I know a couple in Vegas. Just reach out to me by email. My email address will be on my YouTube channel. Let's see. After the inspection, this is back on the apartment. After the inspection, balance was zero. List charges popped up 10 months later. Yeah. Complex went bankrupt a year ago. Can't contact her. Yeah, that's a problem for the debt collectors. So but just send me an email about that. We'll talk about it. I'll try to get you to the right person. Let's see. Oh, you completely disappeared. This is really on the TSR. I think we'll save that one. That's really kind of the.
Look at that, Robert Sigmund. You see that, Robert? That was a Robert Sigmund post. See, Robert, you talked smack about me earlier. John just basically poo-poo canned your question. So Robert, you better be nice to me. That's the power we got over here.
Yeah.
John and I are tight. See
so
that?
here's Robert, and so yeah, that we did one on maybe a month or so ago, and then Robert and Listro and who else was it? Was it Gary Nitskin? I think it was Gary Nitskin. The three of them did a sort of like a live video on going over all this TSR stuff for credit repair companies that I thought was really good. Let's see. Thank you for the awesome webcast. You're very welcome. When discussing the unsolicited call exemption, yeah, so we're kind of getting in that. Hey, you're very welcome, Melissa.
Thank you, Melissa. Thank you.
And that was a Scott Shave question. Yeah. So I've been watching Scott and Robert debate some stuff on the TSR. It's I only understand every third word, but it's interesting to me. All right, let's see here. Well, I think that's it. And hey, we're going to come in just under time. So, well, listen, everybody, thank you for being here in Palmieri, despite all the many bad things I thought about you and the several bad things I said about you. I do appreciate you being on here. So.
That's okay, because for every bad thought you've had about me, I've had twice as many about you, but I still love you as well.
All right, brother.
Thank you guys for watching. We appreciate you guys very much, and we will see you all on the next show.